Members and guests, today is Tuesday, March the 8th, 2022. I hereby call the Civil Justice Subcommittee to order. Ms. TJ, call the roll.
Representatives Clemens, Curcio, Farmer, Garrett, Griffey, Ogles, Parkinson, he was here, Ramsey, Chairman Russell.
Here.
Chairman, you have a quorum.
Thank you. And members, do we have any announcements or personal orders? All right, seeing none, we'll jump right into this calendar here. And to clean up the calendar, item number 22, House Bill 2593 is off notice. We'll take up item number 1 first, House Bill 1898 by Representative Grills. We have a motion. We got a second. We have a second. We do not have a second. Bill fails.
Second on this motion. The firearms bill?
Action's been taken. We'll have to move on to number 2.
Mr. Chairman,
Yes, sir.
can I make a motion that we reconsider our previous action on not getting a second so we can have opportunity to get a second on it?
So we got a motion to reconsider actions on House Bill number 1898. Do I have a second?
Second.
We got a second. We're back on item number 1, House Bill 1898 by Representative Grills. Do we have a motion and a second?
Motion. Second.
We've got a motion and a second. Members, we'll take a brief recess and just get things in order. to everyone in the audience, we're waiting on a quorum, and we'll gavel back in just a few. Well, all right, we're back in session. And Representative Grills, unfortunately, you didn't have a second, so the bill fails, lack of second, and we'll have to go to number 2. So, next up is item number 2, House Bill 2770 by Representative Todd. We got a motion. Do we have a second? And we have a second. Representative Todd, you are recognized on House Bill 2770.
Thank you, Mr. Chairman. And we have an amendment, drafting code 15096.
That's what I'm showing. We got a motion. Now, this is an untimely filed amendment. Is that right, Representative Todd?
If it is, I didn't know that, sir.
Okay. Normally, we don't accept those, but since this is our final calendar, we will this time. But we got to vote if we'll even consider it. So all those in favor for considering Amendment 015096 signify by saying aye. Opposed, no. The ayes have it. Now we need a motion to hear Amendment 015096. Do I have a motion? We got a motion. Do I have a second? Do I have a second? Representative Parkinson. Okay. Representative Todd, you're recognized on Amendment 015096. Representative Clemens.
Thank you, Mr. Chairman. Do we have a copy of this? I don't have a copy of it.
It's on the dashboard. It was untimely filed, so it should be on your dashboard.
Okay.
And,
Thank you, Mr. Chairman.
Representative Todd, you're recognized.
Thank you, Mr. Chairman. And this amendment rewrites the bill, and several little details about this that I'd certainly be glad to discuss. This removes some legal uncertainty first and foremost. Right now, well, this would help balance property owners' rights to disarm people on their property and the people's rights to protect their lives. This clarifies that right now, businesses have the right to ban firearms on their property per TCA 3917-1359, and clarifies that this right comes with responsibility for individuals affected by that choice. It clarifies the legal responsibility for injuries resulting from curbing a person's right and ability to protect themselves. It defines that conditions and extent of the liability, as well as the time frame to bring legal action. This creates a new subsection, TCA 3917-1325. The current 1325 will become subsections B and C. Substantively, this means that the new law defines that if a person or entity decides to ban firearms on its premises, this person or entity assumes responsibility for injuries resulting from that decision. And why is this important? The decision to ban firearms puts affected individuals at a heightened risk both on posted premises as well as on their way to that property and back. To make matters worse, it advertises to criminals that individuals entering, patronizing, and leaving the premises are easy victims or sitting ducks. For example, a criminal observing a petite female or physically weak or elderly person entering or leaving a, quote, gun-free zone can easily spot this person, attack and rob, or even kill them without fear of much resistance. If the person uses public transportation, like a taxi, Uber, sidewalks, if it came by bike or motorcycle, this defenselessness can extend far beyond the posted property. For a person subject to death threats or stalking, this can be daunting, especially at night. And I just implore you to really consider that. That if you've got someone that's a victim of stalking that you're putting them in extra harm's way here. This bill still allows banning firearms, but clarifies that the civil liability that comes with the decision to curb another person's ability to protect themselves shifts. Right now, under current law, if you do not post, if you do not prohibit firearms on your property, you have an immunity from civil action. That's in the law right now. And what I think we have is when people are posting a gun as a gun-free zone, they're not recognizing up front that they're actually giving away that immunity. And that's a concern. I think folks are doing that without being fully informed. And to me, that's one of the biggest things this bill does. It clarifies that when you post, you are now accepting responsibility for these people. You're giving up that immunity that we already have in code. So I think that's some of the biggest issues that I want to come out of this bill. Entering a posted location is not always optional. For example, applying for a driver's license, license plate, registering to vote, actually voting, often requires entry into a location that's been posted. Likewise, an individual may not have a choice but to enter a certain posted private business. For example, if you need to go to the hospital and all hospitals in your area decide to post, or if you filled up your gas tank at the gas station, if one can even afford that now, but the pump malfunctions or you need a receipt, which the pump fails to print. I know many of you have had that issue like I have, and the gas station is posted. Then you might not even see that posting from the pump, or you
Chairman
have an
Todd.
existing business relationship.
Chairman Todd, we ran out of a quorum, so we'll have to go out of session until somebody comes back. All right, back in session, and Chairman Todd apologized for that, so you may resume.
Thank you, sir.
Question's been called. All those in favor of attaching Amendment 015096 to House Bill 2770 signify by saying aye. Aye. Opposed, no. The ayes have it. Amendment's attached. Chairman Todd, you're recognized.
Thank you, Mr. Chairman. And now that we have a pretty full committee, I may need to repeat some of this so that you guys know what we're actually doing. I'll probably start at a different place, but the bill as amended actually, in my mind, provides some clarification to property owners. Right now, there is an immunity that property owners have if they do not post their property as a gun-free zone. They're immune from civil liability at this time. If they post, many don't realize they're giving up that immunity, and that's what this bill does. It clarifies that they're removing that immunity from liability protection and taking on the risk and responsibility of protecting those within their confines. It removes that legal uncertainty. It balances a property owner's rights with the rights of the people to protect themselves. Clarifies that businesses have the right to ban firearms on their property per TCA 3917-1359, and clarifies that this right comes with responsibility, as I said, for individuals affected by that choice. Clarifies that legal responsibility for injuries resulting from curbing a person's right and ability to protect themselves, and it defines the conditions and extent of the liability as well as a time frame to bring legal action, which I think we need in the code to help those folks understand exactly what they're accepting by posting their property. This new law would define that if a person or entity decides to ban firearms on its premises, the entity assumes responsibility for injuries resulting from that decision. As I said earlier, they're already removing their immunity from liability, and this would just state that so that they clearly understand what they're taking on. The decision to ban firearms on property puts affected individuals at a heightened risk, both on the posted premises as well as on their way to and from that premises. It even advertises to criminals that individuals entering, patronizing, or leaving the premises are easy victims or sitting ducks. A criminal can observe someone that may be elderly or feeble entering one of these businesses or premises and know that they're an easy target. And so I'm concerned that we're unfairly putting folks into a really precarious situation. And if you talk about stalking, as I mentioned a minute ago, someone that's a victim of stalking, this just opens them up for more potential harm from their stalker if we don't have this in code. Well, with that, I will certainly be glad to take questions, but I appreciate your consideration.
Thank you, Chairman Todd. And there's two people that were here to testify, so we'll go out of session and hear from them. All right, first up is Carlos, and I'm going to spell this last name, Angulo. And Carlos, you'll have 3 minutes to speak, and when you sit down, if you'll press your little red button there, or trusty official timekeeper here, Ben, he'll let us know when 3 minutes is up, and if you'll just identify yourself for the committee.
My name is Carlos Angulo. I am a retired Metro Nashville police officer, and I currently work as a firearms instructor, and I do private security. I'd like to start by saying that the persons committing gun crimes are typically not your everyday law-abiding citizen. I understand that private businesses and entities have the right to prohibit the possession of either a concealed or open carry firearm, but I also believe that those entities that prohibit the carrying of firearms should be held liable for the safety of its patrons in the event that a criminal incident requiring the use of lethal force occurred in their establishment, and the patron and the establishment was unable to defend themselves. On October 16th of 1991, a mass shooting took place at a Luby's cafeteria in Killeen, Texas. That day, Susan Grasha Hupp was there dining with her parents. Susan would normally carry a gun in her purse, but she had recently stated that she left her gun in her car because at the time it was illegal to carry a firearm in Texas. In the aftermath of the shooting, she stated that when the shooting started, she saw an opportunity to take out the shooter and went for her gun and realized that she didn't have it on her because she didn't want to break the law. It was 100 yards away in her car, and that day, both of her parents ended up dying. My point is that gun-free zones are soft targets, and establishments that prohibit firearms should be civilly responsible if their decision to prohibit the firearm causes the death or seriously bodily injury of one of their patrons. Thank you.
Thank you, and thank you for your service as an officer.
Thank you, sir.
Do we have any question for Carlos? And seeing none, thank you.
Thank you.
Next up is Kristen Benton. Kristen Benton. And Kristen, you'll have a 3-minute time limit, just like Carlos, and make sure your red light's on. Just announce yourself to the committee and who you represent.
Okay. Chairman, representatives, my name is Kristen Benton. Thank you for the opportunity to speak with you all today. I don't have a military or law enforcement background. I'm just a regular mom of 2 daughters. I got a Tennessee handgun carry permit over 10 years ago so I could have options for protecting myself and my children. I'm also a small business owner in Middle Tennessee. My business is She Shoots Training, where I'm a firearms instructor providing defensive training for armed citizens, especially women. 99% of my clients are women that prior to contacting me have never touched a gun in their lives. While they all come to me because they want to be better equipped for danger in the world, their reasons can vary. Many are moms that are feeling the natural instinct to protect their children. I also teach many widowers, as well as women who have been in abusive and violent relationships. Some have even been held at gunpoint. Whatever their individual reason, they all have one thing in common. They feel vulnerable, and they are taking steps to claim responsibility for their own safety. When a business chooses to be a gun-free zone, they are creating a more vulnerable environment for their patrons, effectively removing the ability to be responsible for one's own safety. I want to share some research with you that is important to consider. In 2013, following the Sandy Hook massacre, then President Obama ordered the Department of Health and Human Services and Centers for Disease Control and Prevention to conduct research into cases of gun violence and the ways to prevent it. A committee of experts was convened to study the issue of defensive gun use, and they reported that almost all national survey estimates indicate that defensive gun uses by victims are at least as common as offensive uses by criminals, with estimates of annual uses ranging from about 500,000 to more than 3 million. Studies that directly assessed the effect of actual defensive use of guns have found consistently lower injury rates among gun-using crime. Another study in 2000, published in the Journal of Quantitative Criminology, reported that U.S. civilians use guns to defend themselves and others from crime at least 989,883 times per year. An additional study reports that 60% of convicted felons admit that they avoided committing crimes when they knew the victim was armed, and 40% admitted avoiding committing crimes when they think the victim might be armed. Finally, the Crime Prevention Research Center conducted a survey in which 66% of economists and criminologists answered that gun-free zones are more likely to attract criminals than they are to deter them. While HB 2770 does not prohibit a business from choosing to be a gun-free zone, it's important to understand that when a business chooses to be a gun-free zone, they create an environment that is appealing to violent criminals and creates increased vulnerability for someone like myself or any of the women I teach every week that might otherwise have means of protecting themselves and their loved ones from serious injury or death. If I can no longer be responsible for my safety, then who is? HB 2770 acknowledges that when a citizen can no longer be responsible for their own safety, a transfer of responsibility must occur, and that the business choosing to be the gun-free zone is liable for the safety of its patrons. Thank you, and I encourage you to please vote yes on HB 2770.
Thank you, Ms. Benton. Members, we have any guests for Ms. Benton? And seeing none, thank you for being here. You're making a difference and very enlightening. And we'll go back in session and hear from Chairman Todd. Chairman Todd, you're recognized.
Thank you, Mr. Chairman, and I just appreciate the committee hearing these folks. As you said, we certainly invite the public to be a participant in this process, and what you're doing here this morning, the vote you're going to have on this bill is definitely going to affect people's lives. This not only affects the lives like we heard in testimony here, of individuals that want to protect themselves and know that responsibility they have to protect themselves and their families, but also the property owners. And this does nothing to disrespect property owners. I am one myself, and I know when I had to come up on a situation on my own property with my own employees and make a decision about them being able to carry on our property, I automatically knew that I was taking on responsibility if I asked them to disarm themselves. And I think most people do not realize that they're accepting that liability through the court process. And this just clarifies that so that they know up front, if they decide to post and disarm their patrons, then they're accepting responsibility. Their immunity from liability is going away. In code now, we don't really tell them that, and this would actually put that very plainly in front of them. So with that, I would certainly appreciate your consideration on this.
Thank you, Chairman Todd. And Chairman Farmer, you're recognized.
And thank you, Mr. Chair, and thank you, sponsor, for bringing this legislation. And Mr. Chairman, I just have a few questions. If you don't mind, I'll just...
Absolutely. Go ahead.
Okay, thanks so much. Chairman, and I think I know the answer to this one, Representative Todd. Would this have anything to do with, say, for example, if I had something for sale at my home and I had essentially invited someone onto my property to come and purchase a boat, for example, would that person then be able to carry a firearm onto my private property if this bill passes?
It does not restrict your ability to prevent people from carrying on your property whatsoever. It just clarifies that if you do that, you're accepting responsibility for their safety, which you're doing anyway.
Mr. Chair. And so is the answer yes? Am I accepting responsibility if someone were to get shot on my property, if they were coming on my property to purchase something on my private property at my home?
If you do not post it, according to the code that we have here, 391759, I believe it is, then you have immunity from criminal or from civil liability, is my understanding from what we already have in code. You have an immunity there if you do not post. But what I think people don't realize, most people do not realize, is if they post according to TCA 3917, 1359, is that they're giving up that immunity. And so you still can do that. It's just recognizing that you are taking on some responsibility for that person's livelihood or safety on your property.
Okay. And my next set of questions has to do with liability, right? So we have, say you're Kroger in a part of town that doesn't have much violence, whatever town that may be, right? I'm not picking on any cities or towns in this state or at all. So if you have a place to where there hasn't been any violent crime whatsoever, and a person were in that business posts, say it's a Kroger or Food City or Publix or Whole Foods or whatever, any sort of grocery store that may be, and nothing's happened there in the 45 years that they've been in business, and they posted, said, hey, we don't want any firearms on our business, and that person were to get just randomly mugged and shot in the parking lot. So is this business going to be responsible for that person being mugged and shot because they posted?
That, in my opinion, that's what we already have. If they post it, they're giving up the immunity to liability. So they already have that based on court cases and other things, is my understanding. And this just clarifies that and puts it in front of them to say, if you post, then you recognize that you're actually removing that immunity that we already have.
And my point is this, and there's different types of businesses. I know there's been a few businesses that I'm aware of within the state that liability arises in certain situations, and it causes businesses to have to be more alert. So if someone has been shot across the street or stabbed and walked over and ended up something happened to them near or on their property, then that creates a responsibility for that business to be on a heightened awareness for their patrons. Okay, so I think we have something in place to protect people as is, and that means that these businesses that are in an area or in the business of having in a business of attracting those who like to fight or do things that maybe not happen at the local grocery store during the daytime, that hadn't happened in 45 years, that happens, consistently. I think these businesses have a duty to protect and provide security, armed security, for their patrons, right? So if something happens in that situation, then of course the person, and if that security wasn't provided, that person then would have the ability to sue that business. But my issue comes with, we're talking about insurance premiums here. We're talking about a lot of things for businesses and a lot of liability for businesses that, have no record of any sort of violence. And there's no law that we're going to pass here in the Tennessee General Assembly that's going to stop violence. And guns don't cause violence. Knives don't cause violence. Those folks who have their hands on those instruments cause the violence. But my issue is, we had this debate, back when Bill Haslam was governor, and we had a lot of gun bills come through this committee and sat through hours and hours of debate, and it was about this. It was like, well, let's talk about our constitutional right to carry a firearm, but let's also talk about our property rights. Let's talk about individual property rights, and let's talk about property rights as a business owner, right? And so I think we're back there again. It seems like almost like deja vu, and I think that we came to a good spot when we decided where we're going to allow firearms and where we weren't going to allow firearms in regards to private businesses, because we have to allow them to take responsibility and control for that business that they started, and to care for those patrons that they invite into their businesses. So I think we're going a bit too far with this piece of legislation, in that I think we trust our businesses to have the responsibility and have the capability to protect the patrons into where they're inviting them, no matter what part of the community or what community they're in. And there is, I think, a mechanism for recourse for those who invite patrons in and don't protect them the way that they need to be protected. So there are my issues with the bill, and Mr. Chair, if Representative Todd would like to respond to that, I'd love to hear it. So,
Chairman Todd.
Well, unless I'm misunderstanding, I think you made my case for me, quite frankly, for having this legislation, and that's not being flippant. You made a lot of points that I was already making, that first of all, we're not infringing on the rights of a private property owner whatsoever. They can still post, they can still prevent anyone from coming on their property, whether it's a person selling a boat or whether it's a Chick-fil-A. They can do that right now. We're not taking that ability away, but we are informing them that if you do that, as you said, they're accepting responsibility for their actions in disarming their patrons that come on their property. And the immunity that they have under the current law when they don't post under 1325 is being given up, and they don't realize that. I don't think there's an actual knowledge when they put that 3917, 1359 posting up, that they realize they're giving up that immunity. And that's what this, you could even consider this a cleanup bill. This, with a wink, I say. So, it helps people to understand right up front, if I do this, if I accept this, if I want to make this choice that we provide in law, that we're not hampering whatsoever, then I'm also giving up some immunity there.
Sure.
And Chairman Farmer, you're recognized.
Yeah, just one follow-up, and as you said, if you agree with every point I had, then you would agree that we don't need this piece of legislation. That was my point.
Chairman Todd.
Well, I didn't say I agreed with every point. I said you made a lot of points that I've already made here about why we do need this bill. I just respectfully disagree. I think it's being responsible to our citizens if we make sure they know up front that they're giving up some immunity that they have without posting. That's the concern I have, is that we're being very plain and upfront with them. If you post under 1359, then you are giving up some immunity that you have by not posting. That's really what the intent of this is.
Okay.
Chairman Farmer, any
Thank you,
follow-up?
Mr. Chair. That's all I have, Mr. Chair.
Thank you.
so much.
And
Thank you,
Representative
Mr.
Parkinson, you're recognized. All right. Well, we got a question, but it's been withdrawn. So Representative Garrett, you're recognized.
Chairman Tom, thank you for, Mr. Chairman, thank you, and thank you for bringing this legislation. Couple of comments, and then I'll let you respond. I've got all of us, I've got one personal situation with a client of mine that dealt with the Second Amendment, right? He was watching his son fishing in a tournament near New York. He drove up there. He had his handgun with his car. He decided to go across our border in Canada. And he was charged. He was detained. They charged him with smuggling a handgun into Canada. And he could only talk to his lawyer. So that was me, right? So I was charged with, how am I going to get this guy out of Canada that has been charged with smuggling a handgun that we can carry now even without a permit because of our Second Amendment. So I spent the entire day trying to figure out what I was going to do for this fellow. I got a lawyer in Ottawa, which is where our truckers were. I believe they started there in Canada. And he said, this is a Canadian resident, said, we don't have the Second Amendment here in Canada. Then his words rang even louder, I wish we did, right? Because he was going to be detained until he had a hearing 3 or 4 days later criminally, which he could spend jail for just the possession of a firearm in Canada because they don't have the Second Amendment. So he ended up getting out. He got civilly charged. They confiscated his weapon. He still doesn't have it, and he was able to come home. Goal achieved, right, other than the fact that he lost his weapon. We certainly don't have that ability here in the United States due to our Second Amendment. The second comment I have is that we are witnessing it as a nation in the aspects of what's happening in Ukraine. When President Zelensky asked, when he was offered a ride out of the country, he said, I don't need a ride, I need ammunition, right? They were arming their citizens because they didn't have the ability to fend off a foreign government. In a lot of ways, the Second Amendment gets confused, I think, on what its purpose is. And our purpose is, granted, we enjoy hunting, we enjoy using our firearms in a sport way, but the Second Amendment is really about our government being able to overtake its citizens so we can have an armed citizenry, so it's against the actual actions of the government. It limits the government. No country that I know, no country within our own borders would try to do what's happening in Ukraine because our citizens are armed, which I think is the very purpose of the Second Amendment. So with all of that said, I think I do have, and I think most of our committee members understand what the Second Amendment is. Here's my concerns with the legislation as written, is that we have, and there will always be, an argument on private property rights versus the Second Amendment rights. That's not new in our dialogue as the Second Amendment continues to evolve, or whatever it's going to be, right? So my worry is, and I would just like to get your take on this, is that the old Bank of Goodlettsville building that's in the bank, and the Bank of Goodlettsville was part of my family. It's a 120-year-old building, and my family still utilizes that building, and I have a tenant in there. He teaches art classes. I don't have any signs or anything that says anything about firearms or whatnot. It's not in my lease. It's silent in my lease about anything like that. But In this sense, what if my tenant wanted to post something because he wanted to make it known under current law, as you quoted, that he doesn't want firearms? And my concern is, if your bill becomes law, is that he would not only be responsible, so would I, for the act of a criminal act that I had no connection to, because I'm removed from that building because my tenant's in there. So that can apply across the board on anyone that owns a building that this could affect. I'm not even bringing up some secure facilities that I'm afraid this might run into. But what do we do when now a private property owner could be liable for the criminal act of another that they're not connected to in any form or fashion? And my concern, Chairman Farmer said it this way, that there's going to be no liability insurance that's going to pay. Insurance companies will take your premium, but they will work vehemently to deny your claim, period. They're in the business of not paying your claims or finding a way that your policy doesn't cover a specific instance under your liability insurance. So my fear is that we're going to bankrupt a small business like the fellow that's in my building, or then me, or anyone that's in my particular situation, when they have no connection to a third-party criminal act. Your law obviously protects the law-abiding citizens that's not going to violate the law under their Second Amendment rights, but we know people do, right? That's going to happen. So I'm just, and I don't know if there's a way. I don't know if there's a language that we could amend or what the answer is, but what's your response in a situation where we're putting a property owner responsible for a third-party criminal act that they have no connection to? How does this bill protect the property owner in this instance for their property rights, in the sense when they have nothing to do with a criminal act that took place on their property? That now, if someone dies or is killed, that family is going to have a substantial wrongful death action against whomever is touched on that property. And believe me, they'll sue every defendant they possibly can, which this statute could open up even more defendants. So that's my concern. Did I express that properly, or you could potentially respond to that?
Chairman Todd, you recognized?
I believe so. And I think, as I understand it, right now, that liability already exists, but they don't realize it. For example, we can name several cases. The Colorado the movie theater shooting. I don't have those cases in front of me, but I understand that there were lawsuits that were awarded because they had posted that property and taken away those people's rights to protect themselves. And so they ended up writing some big checks to the victims and victims' families, is my understanding. So I would say that we already have that situation right now. Now, whether they realize it or not I think that's the issue that I have here, is they don't realize it because of the way the code's written. It just said, if you don't want it on your property, you can post it. And they're not connecting the dots to say, I have immunity if I don't post, but if I do post, our law book is silent to tell people that immunity is going away, when in fact it is going away. So that's the point that I'm making, is that this puts it pretty plain and simple that we know up front, if we take this action and put that sign on the door, that we're giving up that immunity. And I don't know if that adequately answers your question or not, but
Representative Garrett?
Thank you. Let's suppose, typically under the law, you are not responsible for the criminal act of another. That's an intervening cause that would break the causation of you being liable to someone, typically, right? So in that regard, if there's not a statute out there that gives someone civil immunity if they post a sign, I don't believe it's that simple. But given the fact that typically you're not responsible for the criminal act of another, if your bill made it where you are criminally responsible if you're liable for the criminal act of another, would you support this bill if that was the unintended consequences of your legislation? That as a landowner or a business owner, you are going to make that landowner, you're going to make Chairman Todd over your business responsible, liability-wise, for the act of a third-party criminal act where you have no connection to. If that's what your legislation does, would you support it?
Chairman Todd.
And I may not be following you, so are you talking about, when you're talking about a third party, are you talking about a building, let's say, that I own, and I lease space to you, you post it, and someone comes into that building, and then into your business, your office in that building, that I would be liable?
Representative Garrett.
Let me give you an example, okay? The art teacher that I have in my building, if he's got someone in there that he's teaching art instruction to, that maybe that particular person there is armed in the building. There is a third party that wants to rob, a criminal that wants to come into the building and rob anybody that's in there, take their purse, take their wallet, whatever the case may be. That's the third party that I'm referring to. So under your legislation, regardless of what's out there now, what I'm asking you is that if that person came into the building and killed that little old lady that's in my building and the tenant, then that family, because your bill is law, would have an action against me as the building owner and the tenant. And you're making me and the tenant, under this legislation, responsible and liable to a third-party criminal act. If that's what I understand your legislation does. So my question is, if that's true, would you still support this if you're making a person responsible for a third party's criminal behavior that has no connection to where the act took place other than they own the property?
Chairman Todd.
Thank you for that. My intention here, and I believe the language, and we can read it and double check that, but I believe the language, and certainly my intention is that the entity posting, no matter what the rented building has to do with this, just the entity that's doing the posting. For example, the person, that art studio that's renting a space in your building, if they post it, you as the building owner did not post it, but if they post it, they're the ones that would be responsible. They're accepting, they're removing their immunity that we have under the law right now. And this just says you recognize that the entity actually doing the posting. So if the entire building, I think someone testified last week that they rent space in like a mall, for example. And so the mall may be posted. Well, the entity renting didn't post it. The mall did. So they're the ones that would be, that the posting entity is my intent to be responsible, not everyone else that has anything to do with the lease or the neighbor or anything like that, just the entity posting.
Okay.
Representative Garrett.
Well, my problem is the language in the bill allows for anyone to be sued. So there's no protection in your sense that would make me, as the owner of the building in my hypothetical, immune from liability, because I will be sued under this legislation because I own the building. My lease is silent to the tenant, so that them posting the statute may or may not apply to the actual building owner. So I just say that there's some scenarios here that I'm afraid we're making property owners responsible for the acts of third party, a criminal act. And I just want to make sure, I don't believe that's your intent of the bill. I really don't. But I just think that's a concern that we need to address and see if we can figure out a way that in that scenario, a property owner that has no connection at all to the criminal act, we cannot hold them liable for that. And that's where I have some issues, because I don't know how you're going to insure over that potential loss. That is a concern of mine. So,
Chairman Todd.
On the amendment, Section 3A3, Section 1A3 states that the responsibility of the posting person or entity for the safety and defense of the person authorized to carry a firearm pursuant to this part extends to the conduct of other invitees, trespassers, employees of the person or entity, vicious animals, wild animals, defensible, man-made, and natural hazards. So it specifically talks about the posting entity there, and it may not be clear enough, and I'm certainly, because again, my intent is the entity posting should be the responsible, and only that entity posting. That's the intent. So if it's not clear, then certainly I want to make sure it's clear. So I would certainly be glad to amend it. If we can get beyond this point, be glad to amend this.
There's definitely a cool breeze flowing through. Representative Garrett,
Thank you for indulging my questions. I appreciate it, Chairman Todd.
Representative Griffey.
Thank you very much, Mr. Chairman. I don't have a problem with that issue. My experience with commercial leases, the property owner always gets indemnity for whoever's leasing the place for whatever actions that lessor is conducting on those leased premises. In addition, under Tennessee's comparative fault, comparative negligence, whoever's the claim is going to be adjudicated by the jury. They're going to be evaluating everybody's potential liability for their actions, actual actions involved. And so I don't think we're actually changing the liability in this case. We're just specifying that to landowners, or not really landowners, whoever posts property, that if you post it, you're going to be responsible for people coming on this premises that you've disarmed and not allowed to exercise their own Second Amendment rights. So I don't have a problem with the bill, and I support it. Thank you.
Chairman Todd.
Thank you, Mr. Chairman, and I appreciate that. And that's, again, that's the intent here. It's not to bring liability further than it already is right now, simply to the entity posting. So if there's a concern with the language that it's not clear enough, I'll be glad to amend that in full. If we can just get it out of the subcommittee, I'll be glad to work with you and make sure that we get that right so that the intent is accomplished.
Okay, the question's been called. Okay, it's withdrawn, and Representative Clemens, you're recognized.
Thank you, Mr. Chairman. As a gun owner with a carry permit or otherwise, you have the option to enter businesses of your choosing, correct?
Chairman Todd.
Private businesses, yes.
So you can choose not to go in a business, not to go in a home, not to go in an environment that may prohibit firearms on that private property.
Chairman Todd.
That is certainly the case, and many people do exercise that right of choice and choose not to go into entities that post. But those that must go into entities that post, for example, the ones that I read earlier, where they're required to go in to vote or to get a driver's license or register their vehicle or whatever that might be, just because that entity felt like they should disarm law-abiding citizens, this is just recognizing that they're accepting the fact that they're giving up their immunity from liability.
Representative Clemens.
Thank you, Mr. Chairman. The infringement on the rights of private property owners threatened by this bill are simply too much. They outweigh any benefits of the legislation. Thank you.
Chairman Tolman, would you like to respond?
Thank you. I don't believe we're infringing on anyone's property rights. We are literally stating they can still post anytime they want to. They're just recognizing that they're giving up the immunity that they have by not posting.
Thank you, and I want to thank you for what you're doing to protect our Second Amendment rights. And we don't have anybody else for questions, so we'll be voting. Okay, Representative Ogles.
Sorry about that. To the sponsor, and I appreciate the testimony that was given today. That really kind of opened my eyes to some issues I didn't think through, especially seeing children here and thinking through, like, what do I do sometimes when I go into a business and there's posted. Unfortunately, I have problems seeing sometimes, and sometimes that sign is really hard to locate if not placed properly. But to your knowledge, if a business is open to the public, what capacity do they have to post and deny people of civil rights? For instance, if I own a bakery, can I post a sign that says, I'm not going to serve minorities, or I'm not going to serve people from Canada, I'm not going to serve Christians because I choose not to obey that law? To your knowledge, is the companies have the capacity to do that?
Chairman Todd.
I'm certainly not an expert in that. You have several on your committee that probably could answer that better than I. But I know it's not right to do that for certain. And again, we have certain rights given by God. Then some of them, a few of them, are enumerated in our Constitution. They're not exclusive, as you well know.
Representative Ogles?
And,
I'm sorry.
sorry.
And go ahead, Chairman.
You know, a private business just cannot ask someone to give up their right to free speech, for example, coming on their private property. But, you know, again, that seems to always be treated differently here in the legislature. Our right to free speech and assemble and so many other things are always treated different than our Second Amendment rights, and I don't understand that. So to your point, I don't believe they can. I don't believe they should, certainly.
Representative Ogles?
Thank you for that. I know there's some concerns on this legislation, and I'm willing to work with the sponsor on amendments in the full committee if there's some things that need to be cleaned up. But I definitely think that we have to be careful on limiting people's rights, especially to businesses that are open to the public. Now, if we're talking about private personal property rights on a private residence, I do think that's a different issue, and there's a different issue to businesses that may not be open to the public at large. You can have commercial property, you can have a place of work but once you open that up to the public at large, I do think we need to differentiate on some of this legislation because I feel like there's a double standard. We've told business owners you have to service the entire community. You have to provide your service to everyone because they have civil rights, yet we limit some of their constitutional rights to bear arms simply because we've subjectively, I can't say the word, subjectively applied that to the Second Amendment. So I'll be supporting your legislation.
Thank you. And Chairman Todd, you got any follow-up?
I do appreciate that, and I thank you for raising that point. I thought about it during some of the questions, but did not make that point, so I appreciate you connecting those dots.
Representative Griffey, you're recognized.
Thank you, Mr. Chairman. Can we just have a roll call vote on this legislation, please?
That would have had been requested at the first or three hands by the committee members.
Mr. Chairman, I'm making a motion, and I'm one hand.
All right, we've just got two hands, so we'll be doing a voice vote. Okay, with no more questions, we're now voting on House Bill 2770 to send to civil full. All those in favor signify by saying aye. Aye. All those opposed, no.
No.
The noes prevail. Bill fails.
Thank you, committee.
Next up, item number 3 by Representative Hazelwood, House Bill 1768. We've got a motion. Do we have a second? We've got a second. Representative Chairwoman Hazelwood, you're recognized, and I do show an amendment. We have a motion on amendment. Do we have a second? We have a second. And just to clarify your amendment number, would you?
Yes, the amendment number is 013976.
That's what I show. Chairwoman Hazelwood, you are recognized.
Thank you, Mr. Chairman. This is a simple bill. The amendment simply changes the amount, but this bill is permissive. It would allow court clerks to charge 20 cents as amended, 20 cents per page for the purpose of printing a paper copy of any filing. These charges would not apply in the case of an indigent client or a party representing an indigent client. It is entirely permissive, and with that, I would just request your approval on the amendment.
Thank you. Any question? We got a motion. The question's been, we've already got a motion in a second, so has the question been called? Or okay. We're voting to add amendment 013976 to House Bill 1768. All those in favor signify by saying aye. Opposed, no. Amendment added. And Chair Lady Hazelwood, and the question's been called. We're voting on House Bill 1768 to send to civil full. We've got a question up here. Would you like to withdraw? Okay, Representative Clemens, you're recognized.
Thank you, Mr. Chairman. My question was, you partly addressed this, having access to the courts is a serious thing, and you said this doesn't apply to indigent clients and things like that. How did you land on the 20 cents per page? That's what I'm kind of, because some of us lawyers, we file a lot of documents and we need to get a lot of copies sometimes. So
Well, a lot of the courts do a lot of electronic filing, and, copies are no longer required, but it does cost the clerks' offices, they have to pay to have somebody to make the copies, pay for the paper, all of that. We originally started with 50 cents and determined that that might be a little prohibitive because, as you mentioned, some filings are quite large, so we reduced it to 20. And I point out this again is permissive, so the court clerks would determine in their particular areas whether or not they wanted to lay this charge.
Representative Clemens.
thank you, Mr. Chairman, and thank you for that, Chair Lady, for explaining that. And does this have any of the courts associations, bar associations, anybody, did the court clerks bring this to you?
My court clerk brought this to me.
Okay, thank you.
Okay, seeing no more questions, we're now voting on House Bill 1768 to send to civil full. All those in favor signify by saying aye. Opposed, no. Bill passes. Congratulations, going to civil full. Next up, item number 4, House Bill 2501 by Chairman Rudd. Chairman Rudd, you are recognized. We do have a motion. Do we got a second? We got a second. Bill fails like a second. Next up, item number 5, House Bill 2533 by Chairman Ramsey. We got a motion and a second, but we don't have a chairman. Oh, we do have a chairman. All right, Chairman Ramsey, you're recognized, and I do show an amendment. Do you want to run your amendment?
Yes, sir. Thank you, Mr. Chairman. We have amendment to 13796.
That's what I show too. We got a motion and a second. Does it make the bill?
It does. It rewrites the bill. Yes, sir.
Okay. Would you like for us to go ahead and vote and add it so you can explain the bill?
That would be great.
Okay. All those in favor for adding 013796 to House Bill 2533 signify by saying aye. Aye. Opposed, no. Amendment's added. Chairman Ramsey, you are recognized.
And thank you, Mr. Chairman. In the last few years, Tennessee is ranked within the top 2 or 3 states in concerning men killing women. The vast majority of these victims know their murderer. This bill, as amended, is a simple, no-cost answer to address the breaks in the safety chain that protect our citizens from preventable domestic violence. What this bill does is requires a sheriff, deputy, sheriff, or constable prior to or at the time of serving someone with an order of protection or ex parte order of protection they must make reasonable efforts to determine whether the person being served has an outstanding criminal warrant. It requires the sheriff, deputy, sheriff, or constable in cases in which the person being served has an outstanding criminal warrant to, number 1, either serve the criminal warrant, or number 2, notify the agency holding the warrant of the person's location. And you can ask why do we need this bill? And I'll refer to a well-publicized tragedy that happened to 2 ladies from Lebanon. Marie Varsos and her mother, Debbie Seco, were brutally murdered by Marie's ex-husband, Sean Varsos, on April of last year. These 2 well-educated Caucasian ladies with financial stability actually did everything that was required of them to participate with law enforcement and protective services, and still that failed them. Mr. Varsos had 2 outstanding warrants, one for false imprisonment and another one for aggravated assault against his ex-spouse. She immediately filed the warrants after the incident, and so when Mr. Varsos was served with the order of protection that she asked the court to file, the law enforcement agency serving the order didn't check to see if he had any outstanding warrants, and so they let him go. What if he eventually hunted down his ex-wife and his mother-in-law and shot them dead on neighbors' properties? arresting, and I want to say, what if we had this, and the arresting of Mr. Varsos at the time, the order of protection was served, could have deterred him from committing the murders, or at least given a knowledge of his presence or whereabouts. While most Tennessee law enforcement agencies do make an effort to check for criminal warrants, it was not done in this case. Making it mandatory will hopefully close the gap in the criminal justice system and help prevent future violence and spousal abuse. What was the penalty for not doing this in this case was 8 hours of suspension for one employee. So it's a glaring issue. We have what we think is an amended version of how to address it. So with that, I'll await questions and refer back to Mr. Chairman.
Thank you, Chairman Ramsey. We got any questions for Chairman Ramsey? All right, we got a question on the bill. We're voting to send House Bill 2533 to civil full. All those in favor signify by saying aye. Opposed, no. Ayes prevail. Congratulations, you're going to civil full. Thank you. Next up, item number 6 by Chairman Kumar. Chairman Kumar. You're recognized on House Bill 2850, and I show an amendment. Or do you want to run that amendment?
Yes, sir.
Thank you. And what amendment code do you show? Well, we got an amendment. What code do you show, Chairman?
Mr. Chairman, I'm a little confused. I have a few amendments, but this was the one that was filed late yesterday.
Okay. And what amendment code is that?
I don't have a code. I can get it.
I show 015192 as an untimely filed amendment. Is that correct?
Yeah, that is correct.
Okay, what we have to do, normally we don't do the untimely filed amendments, but we will this time since it's the last calendar. So we have to have a motion and a second to even consider the untimely filed amendment. So do I have a motion and do I have a second? We do have a second. So all those in favor signify by saying aye. Opposed, no. All right, the ayes prevail. Now, does the amendment make the bill?
Yes, Mr. Chairman.
Okay, would you like to add the amendment to the bill and then explain the bill?
Yes, Mr. Chairman.
Okay, so do I have a motion and a second for amendment 015192? We got a motion and a second, so all those in favor of adding amendment 15192 to 2850 signify by saying aye. Ayes and opposed, no. The ayes have it. All right, Chairman Kumar, you are recognized on House Bill 2850 as amended.
Thank you, Mr. Chairman and committee members. Members, since we passed a constitutional carry in the state of Tennessee, the requirement to take a gun safety course no longer applies. And you know, and I know that there are citizens who will benefit from a gun safety course. Gun safety is very important, and by proper training of our citizens, we will be able to prevent tragedies. Since we cannot ask people to take a gun safety course, we can incentivize it. And with that, I had approached administration and governor and hope to get funding, which I'm happy to say I'm told that the governor has decided to fund it. So this will incentivize the citizens who purchase a gun so that they will go ahead and take a gun safety course. They will receive a voucher. Voucher will have a number but no other identification names or anything that can potentially be traced to the gun purchaser, because I think privacy and gun rights are very important to us, and I've taken precautions to avoid that, any interference. So the person purchasing the gun will receive a voucher at the time of the purchase. They will be able to take the voucher to a gun safety instructor, receive instruction, and the gun safety instructor will be able to submit the voucher to the department and get compensated. The voucher is $30. The average or median cost of a gun safety course is about $32. So I think a little bit of copay is actually good. I'm from the medical profession. And with that, Mr. Chairman, I'm happy to answer any questions.
Thank you, Chairman Kumar. And we do have some questions, but we're going to go out of session first and hear from the Department of Safety. So we will be out of
Thank you.
session. And Ms. Stroker, if you'll just do your routine and press the red button, tell who you are, and you've got 3 minutes.
Elizabeth Stroker, Legislative Director for the Department of Safety, and this will not take 3 minutes at all. We met with Chairman Kumar yesterday afternoon on some of our concerns still with the bill, and we sent him some language. I don't know if it was included in that late amendment. It may need to still be included later. That's going to clarify some of our concerns to make sure that somebody couldn't submit this to us fraudulently just to get reimbursed without actually teaching the course. And once that language is added, we'll be okay. And, you know, we talked with him and totally okay if it gets added later. If it needs to move out, we've sent him that language, and I think it's being drafted. So that'll address our concerns.
Thank you. And any questions for safety? Seeing none, we'll go back and Chairman Curcio.
Thank you, Mr. Chairman. I've got to ask, since you brought it, that even if you don't have it in front, can you describe us what the language is or how you would do that?
Ms. Stroker.
Yes, so we are going to start it off as a pilot to see if it's going to work over a couple years, see if this is actually being used, beneficial. And then what we're going to do is require that the schools that we certify that want to send this to us for reimbursement, they have to either sign something or provide something to us saying, hey, I actually taught this course. And then if they are found to be lying about that, because we don't want where a school, which our schools are great, so we hope this would never happen, but gives us 100 vouchers and then we can't verify that they actually taught anything. So it's going to require that they actually sign off that they actually did teach the course. And if we find out that they lied about that or did not do it, we would be able to either, temporarily suspend that school or be able to not allow them to apply for reimbursement in the future.
Chairman Curcio.
Thank you very much.
I've got a couple of questions. Yeah. Is it when you say pilot program, is there a sunset that you're going to recommend?
We recommended 2 years to start to see how it's going, see how much it's being used, and then see if it needs to be adjusted and things like that. So we were starting with 2 years is what we recommended to the chairman.
And is it going to be similar to the driver's safety classes that y'all got to reduce the points on driver's license that you all go regulate?
Yeah, so it's the schools that we currently already regulate, so it doesn't require us to add any more schools or to do any more regulation. It would be those schools that we've already approved to do the training that we provide the material for and regularly review and audit and stuff like that.
Thank you. And Representative Parkinson, you're recognized.
Thank you, Mr. Chair. I didn't even realize you looked my way. But I see you got the old eagle eye on me, so thank you for that. And Counselor, there was money allocated in the last budget, if I'm not mistaken, for gun safety courses. Do you remember how much money that was, and what are we doing with that money?
Ms. Stroker.
Yes, that was, Chairman Ogles is looking at me because that was something he was very familiar with. There was, I believe, $500,000 allocated, and that deals with specifically gun safety with children, not these type of courses. That was being used to help children deal with firearms safely. We're working with TWRA on that, and it was more geared towards school-age children. This is separate.
Representative Parkinson.
Okay, and maybe I'm mistaken, but I know when we passed permitless carry, it was put into that budget, but I was told by Leader Lambert that money was available for anyone. So am I incorrect in that?
Ms. Stroker.
I'm not sure on that. It may have been that it changed later, but I know as we've been developing the program, it's a program we're working on to educate school children on how to safely interact and handle firearms.
Okay. Representative Parkinson.
Thank you.
Okay, seeing no more questions, we'll go back in session. Chairman Kumar, you're recognized.
Thank you, Mr. Chairman. I want to thank the Department of Safety for working with me. I think I have ideas and we turn into a bill and develop legislation. It works better if the stakeholders and departments play a role in it. I'm grateful for their role. I'm agreeable to whether we make it a pilot or an ongoing program. I think pilot is a good idea. And I think that's a very good caution so the vouchers are not misused, that the school providing the course certifies that they have actually done so. We've also added certain other safety measures, that there is a watermark on the voucher so that nobody can run copies of it and so on. So I think these are good precautions, and I'm grateful to everybody for helping. Thank you.
Thank you. I don't show any questions, so I've got a couple. Would the TWRA hunter safety class count as a gun safety course?
I'm not aware of that, but this one will count as a gun safety course towards if somebody wants to get a constitutional carry permit.
Okay, but for the voucher, would it count?
Yes.
Okay, Representative Griffey.
Thank you, Mr. Chairman. Thank you, Dr. Kumar, for bringing this bill. My question is, why are we asking the state of Tennessee taxpayers to incentivize the gun safety courses? I think, I'm not certain, don't hold me to this, but actually there's some firearm retailer sellers that actually will offer the discounts on the courses if someone comes and buys a firearm from them. And to me, that seems like maybe a better approach, at least arguably to some, and not have the state get involved with subsidizing with taxpayers' money the gun safety courses.
Chairman Kumar.
I think any additional discounts that the schools offer are welcome on top of this. But the reason for this doing is it is public safety, and state has a compelling interest in doing everything we can about public safety because we took the requirement for gun safety training away. State has a very important interest in doing that.
Representative Griffey.
Well, doesn't that same argument carry over? Shouldn't we be offering gun safety courses to every high school student in Tennessee? I mean, if we're going to talk about gun safety. So, and that, you know, they could be part of an extra credit course or something like that. So I throw that out there for consideration as well.
Chairman Kumar.
I am all for gun safety training and courses. And if you want to bring that, I will support it.
Any follow-up? And Representative Garrett, you're recognized.
Thank you, Mr. Chairman. Dr. Kumar, we spoke a little bit yesterday on my concerns, and I'm not totally convinced we're not creating some sort of avenue to track people that are purchasing guns. And so my question is, would you be open to decoupling the purchase to a gun if you want a voucher? Why do we have to make it connected to a gun purchase? I get that that's the time people need to get, you know, any sort of safety training, and believe me, they need to do that. But of course, it's not required for them to do that, but they certainly need to do that. And my thought is, if we decouple it from the actual purchase, we can make the voucher expire with a certain amount of time after the purchase, where they then have to have the receipt and prove that they purchased it, so the voucher can still be, you know, used, but it doesn't have to be, in my opinion, connected to the actual purchase of the firearm. And if that's the way the legislation will remain, I don't believe I can support it. So what do you think about trying to decouple it from the purchase of a firearm and then making that voucher expire if you don't show the, you know, within a certain period of time after the purchase of a firearm, that voucher order expires? What is your thoughts on that?
Chairman Kumar.
The voucher does expire in 30 days in this situation. I think decoupling, you and I discussed it. My feeling is when a person buys a gun, it is on their mind. Safety needs to be impressed upon them at that very time, and I think that is the time to do it. I think as far as the vouchers are concerned, no, they're not, they don't last forever or anything like that. Thank you, Mr. Chairman.
Good, thank you.
Representative Parkinson.
Mr. Chairman, my colleague had his hand up first. If you don't mind, I'd prefer to come back.
Representative Clemens, you're recognized.
Thank you, Mr. Chairman. I just wanted to point out that the amendment we've adopted has a provision in there that says the voucher must not contain information that identifies the purchase of the handgun or the type of handgun purchase. So I think the sponsor tried to address that concern somewhat that was raised previously, but I may be incorrect. You can correct me on that if you want, Mr. Sponsor.
Chairman Kumar.
No, again, the idea was to avoid traceability because I think privacy is very, very important in Second Amendment and gun rights.
Representative Clemens, you got any follow-up?
No, I just thought it was important to point that out. I think he's trying to address the concerns that were raised, and I think there's language in there that does that or seeks to do that.
Thank you for that. Representative Parkinson.
Thank you, Mr. Chair. And so, you know, this is something that I stand on in regards to gun safety. You know, however, here's my challenge with this bill. It only benefits those that are selling guns and those that buy guns. And, you know, let me speak for my community. My entire community needs gun safety classes. And they would be excluded if they didn't purchase a gun, and I think it's from a gun dealer, right? But my entire community can use these gun safety vouchers because, as I said on the floor, when we passed permitless carry, my biggest concern was ignorance of the law. And these gun safety classes teach you when you can pull that weapon, use that weapon, and you know, what cases, scenarios, and you know, and I think everyone can benefit it. So why are we only tying it to people that are buying guns from gun dealers and not allowing anyone in the state to have access to these vouchers?
Chairman Kumar.
I think, again, majority of the purchases do happen through gun dealers. When a person buys a gun, a good percentage of them, 30 to 40% of them, it may be the first gun purchase. Their familiarity is limited. And I think that is the time to impress upon them that gun safety is very important. My dealer gives me an example of an 80 and 85-year-old sisters who are widowed living together. They're watching television, they see crime, they get scared. They come over to my gun dealer and want to buy guns, never held a gun in their hand before. Now that is the time to impress upon these people that gun safety is important and incentivize them. As far as the community at large receiving gun instruction, I think so. I think our administration took an effort initially at the school-age children in schools, $500,000 that was put into the budget last year that to provide, again, gun safety education. Beyond the high school level, as you say, your entire community needs that. I agree with you. I think it will do good. Now, I don't know if the state of Tennessee at large can undertake to provide free or subsidized gun safety training to the entire people. That may be more of a community drive organization so that there are volunteers from law enforcement who would love to come and teach. I think that is the route to go. That has to be a community-based initiative. That would be my thinking about it. This bill is basically, again, covering the basis for people who have purchased a gun, who could use safety instruction. We are incentivizing them to make our society safer. Thank you, Mr. Chairman.
Thank you. And Representative Parkinson, you're recognized.
Thank you, Mr. Chair. What's the fiscal note on this bill?
Chairman Kumar.
It's between $2 to $3 million.
So the fiscal note, Mr. Chair, do you mind? Okay. The fiscal note on this bill is between $2 and $3 million for a certain sect or group of people to receive a voucher for tax dollars to go to a gun safety class. Do you have a lot of heartburn with allowing anyone to access this voucher, or is that a big issue for you? Would it harm your bill if the fiscal note stayed the same, but people access the voucher until the vouchers ran out? Would that be a big issue? Because everybody needs this, not just even the people that own guns right now, adults, need these gun safety classes, and really more people in higher risk communities need it more than others. You know, this voucher that'll reduce some of that cost for, you know, these gun safety classes. You know, and honestly, I would like to see. I agree with you in the idea, and actually, I was going to sign on to the bill, but for people in poor communities who need that discount more than anyone, you know, they don't even necessarily have access to the bill because they might not be buying a gun from a gun dealer. Might not even be able to afford one, but have one, but need the gun safety classes.
Chairman Kumar.
Thank you. Representative Parkinson, I agree and identify with the points you're making, but the high-risk communities and the crime there, that's a much larger problem than gun safety courses alone. And also, we are not going to be able to subsidize, again, the entire state, $3 million would not do that, or $2 million would not do that. And again, the idea is for purchaser of guns who have a dangerous thing in their hand, let us cover the bases, let us instruct them, and this will be good for our society. I really would love you to sign on to it. For your larger aim, I'll work with you.
And I respectfully disagree. Being a person that lives in those communities, that gun safety is not the issue. Gun safety is actually the issue, and the more education that we make available to those individuals, the better it is. And I want you to think about what's happening. We offer free gun safety classes through TWRA, which is a foreign acronym in these communities, right? Free. Now we're offering vouchers to people who buy guns from gun dealerships, which most of these communities of poverty don't buy guns from gun dealerships for the most part, and they have them either passed on to them or from grandfather or whoever, but they have them. Now, we have shootings that are taking place on a regular basis in these communities. People that would have been educated, I'm sure we could have reduced some of those shootings. Right? A lot of these shootings may be someone defending someone breaking into their trunk of their car, which is illegal, which is aggravated assault if you pull a gun on somebody breaking into the trunk of your car or climbing over your fence, if there was no threat to you at that moment. These people need these gun safety classes, but we're going all around them. The children that are associated with TWRA, free gun safety classes. I hadn't seen any of those gun safety classes at Raleigh, Egypt. The people, the individuals that buy guns from dealers, and I'm assuming we're talking with some of the gun shows too. Is that correct? Dealers are at the gun shows, right? We know what the target demographic is for people that go to the gun shows and buy guns, so they're going to get a $30 voucher. But no one has addressed people in the hardest hit communities, that need to defend themselves, and have drafted anything that would benefit those, reduce it or make it free for them to get gun safety classes. And this bill is doing exactly the same thing. And I was honestly under the impression that the $500,000 that was put into the budget for gun safety classes was for everyone, but it was only for the TWRA, as I'm learning today. So why can your bill not open up for everyone to have access to it until it is exhausted, and then we come back and do it again?
And Chairman Kumar, we've got about 2 minutes if you can make it quick.
I'm glad that I have only 2 minutes. Number of things and assumptions on your part. The $500,000 that is belonging to K-12 school education, I think TWRA's program is separate from it. 1, 2, you're confusing gun safety, which is how to handle a gun safely, how to store a gun safely, and how to use it safely. That is completely different from having break-ins and robberies. That is malintent. That is not gun safety training. I think you're confused about it. Thank you, Mr. Chairman.
Thank you. And Chairman Farmer's next on the list. Question's been called. We're voting to send House Bill 2850 to Civil 4. All those in favor signify by saying aye. Aye. Opposed, no. Noes have it. Bill fails. We're going to roll all the other bills to next week, and without objection, roll to next week, and without objection, we're going to be out of session. Correction, adjourned.